Welcome to the Visa Mo, Sagot Ko, ang kauna-unahang lingguhang talakayan ng mga bagong balita at batas ukol sa Australian Migration Law and Process. Tuwing Miyerkules 6 to 6:30 ng gabi mula sa Auspac Visa. Auspac Visa is a trusted Australian migration agency for Filipinos all over the world. Auspac Visa is the home for all Filipino professionals, skilled workers, partners, families, students, graduates, and trainees who want to visit, live, work, and permanently stay in Australia. Makipanayam dito sa Visa Mo, Sagot Ko, ang kalahating oras na talakayan ng mga balita, batas, proseso, at mga isyung tungkol sa pag-a-apply ng Australian Visa. Kasama niyo po si Teresa Cardona, Director, Lawyer at Registered Migration Agent mula sa Auspac Visa sa Brisbane, Australia. Paalala lang po na ang mga talakayan at mga impormasyong mababanggit sa programang ito ay sa pawang mga impormasyon lamang at hindi payong legal at hindi rin at walang kinalaman sa mga personal at natatanging sitwasyon ng mga nanonood at nakikinig. Ang Australian Immigration Law ay madalas na nagbabago kung kaya't makabubuti na ugaliing magsayasat at humingi ng payong akma sa inyong pansariling pangangailangan. At ngayon, live mula sa Brisbane, Australia, ang inyong host at tagapagtalakay ng mga balita, issue, batas at proseso na nauukol sa Australian Migration and Visa Application, Teresa Cardona, Director, Lawyer, and Registered Migration Agent from Auspac Visa.
Evening. We're here once again live. It's Wednesday. It's 5:30. So we're going to be with you to discuss the family law in Australia. And we shall be covering all the rights and the interests and the obligations, benefits, whatever for migrants in relations to family law. It's a very, very interesting night tonight because we are going to have the expert in family law. Bihirang-bihirang makasama ang ganitong klaseng tao na merong napakataas na qualification. So we're very, very happy for that. But before that, can I have a look kung sino-sino ang mga kasama namin ngayon? Again, just for a while, I'll just have to fix my my screen to see that we are live now. Just hang on. Okay. All right. So, yep. So, say hello if you are there and let us know kung taga saan kayo dito sa Australia, or if you're watching from the Philippines, say hello as well. And also, kung may mga questions kayo about family law later on, if there are some issues that you wanted to be dealt with at the moment, ask it away because we have the expert sa family law. Hindi lang family law ang expertise ng ating guest for tonight, ano? Ang expertise ng ating guest for tonight ay also covering the Philippine law, because our guest tonight is, I'm really very proud of this person. Actually, nung na-meet ko siya, sabi ko, oh wow, it's not every day that you see a Filipino with this, high qualification. And I'm so lucky that I was able to meet him, know him, converse with him. Marami kaming iba't ibang bagay na napag-uusapan. Paminsan-minsan may kasamang kung ano-anong mga issues na nakikita sa ating mga paligid. Okay, so our guest expert for today is a UP graduate. Not just a UP graduate, but he is a cum laude also a graduate of Bachelor of Laws in UP Diliman. And of course, isa pang pinakamataas na nagaling niya. He was number 17 in 1997 bar examinations. So we're very, very proud of him. He is now a law lecturer in one of the universities here in Queensland, also a Queensland solicitor and a family law expert. But the most beautiful thing here is even if we don't see him around every day, he is very much involved with community works. We don't see him very often because he's very busy helping a lot of people because he's a volunteer solicitor at Pine Rivers Community Legal Center. He's also a volunteer solicitor at Brisbane Northside Connect Legal Center. So kung hindi niyo siya nakikita sa university, for sure you will be able to see him in these legal centers helping a lot of people, not just Filipinos, but all other people in the community. So without further ado, tama na siguro yon. I know napakahaba ng resume niya at napakaraming achievements, pero I hope I'm giving a good introduction for him. And then let us listen to him. So his name is Manuel Oison, but we call him Manjo Oison. So let's, drum roll for, for Manjo. Okay, so Manjo, here's Manjo with us tonight. So Manjo, you want to say hello to the audience at the moment?
Yeah, salamat. Tess, di ko alam kung sino pinag-uusapan natin kanina. Nahanap ko sino sinabi yung magaling.
Napaka-humble naman.
Okay, so salamat sa mahabaang introduction at salamat sa mga tagapanood sa ating maliit na presentasyon ngayong gabi. Ako po si Manjo Oison, I live in Brisbane. At salamat sa inyong pagdalo sa ngayong sa gabing ito. So tonight, well, I'm from Cebu, no? So hirap ako mag-Tagalog, kaya minsan I'm just gonna shift to English. Tonight, I'm going to be talking about family law for Pinoy visa holders. Nung binigay sa akin ni Tess yung mga topics na gusto niya pag-usapan, I got the sense that a lot of the family law matters that needed to be discussed actually related to those instances when a marriage or a relationship may fall apart. And that's when we need to talk about family law. And I think it's quite common for us to hear of many instances where Filipinos actually break up when they come to Australia or when they migrate abroad. Mainly, number one, I think because of the many pressures involved in migrating to another country. It could be about financial and economic matters. But maybe for others, there's a change in life, change in dreams, change in aspirations. And perhaps even for others, they find better opportunities, better partners, maybe even. And all of these factors, when they come together, they often lead to a breakup in marriages. And when these happen, therefore, it's very important for Filipinos to be quite aware about the family law that potentially can affect them, affect their property relations, and affect their children. Now, before I continue, there are two things I'd like to point out. One is that as I make my presentation tonight, this should not be taken as a way of providing legal advice. If you want legal advice pertaining to particular legal matters or dispute, you should consult with a solicitor. So I'm doing a presentation merely for an educational purpose. And secondly, I was hoping to actually spend time with you up to 7 p.m. But tonight, I need to go out to celebrate my son's birthday. So I need to leave at 6:45. And therefore, I will leave the rest of the time after 6:45 to Tess. Tess also has kindly sent me some questions that some of you may wish to ask. I wouldn't mind answering them, and I hope I will be able to answer them by going through the presentation. I would actually have preferred to actually see your faces there. It's different. I've been doing this in Australia for the past 10 years, and I often enjoy having a chat as I do my presentations or lectures or tutorials with students. I prefer having these discussions face to face, and all I see now is just the PowerPoint slide. But so you're gonna have to forgive me if that's the case. I would have wanted to reach out to you. I'm not even sure if you're permitted to ask me questions directly, but if you happen to have any question, please feel free to send them to Tess, and if I could, I'd be happy to interrupt my presentation and try to answer the question. But I think at the end of this presentation, at the end of this short presentation, you should have a good sense about what you can expect if, unfortunately, your marriage falls apart, and you really need to find out about Australian laws. So tonight, these are the topics I'm going to be covering. I'm going to be covering Philippine and Australian marriage and de facto relationship laws. I'll be talking about separation and divorce. I'll talk about domestic violence and domestic violence orders. I'll talk about child care arrangements, which in the Philippines we typically call about child custody, but in Australia we don't really talk about child custody, or rather we talk about child care arrangements. The focus is not on rights of parents, rather in Australia we talk about the responsibilities of parents. So that's a shift in paradigm, or the way that the courts and the laws in Australia approach child arrangements when families disintegrate or they fall apart. I was also thinking of talking about child support agreements, because that can be an important issue to talk about. I'll be talking about dispute resolution, and then I'd be happy to answer a few questions when they come. So you will notice that, and I'm hoping you're actually able to see the screen that I'm showing here. And so you will notice that as far as the topics that are being covered are concerned, we talk about the key aspects of the laws in Australia that may be affected when a marriage or a de facto relationship breaks down. I won't be providing advice or talk about how to soothe yourself, because you're in a breakup, you don't know what to do. So I'm not going to be talking about psychology, but I will talk about the law as much as I can. Okay, so we could probably proceed. Yeah, okay, let's begin. So let's talk about marriage and de facto relationships. In the Philippines, let's begin by talking about rights. In the Philippines, it's quite common for people to say, to make a distinction between people who are married and those who are in a de facto relationship, or those who are cohabiting. Ano bang Tagalog dun sa atin? Nagli-live-in. Okay, so we call it nagli-live-in. Okay, and then if people are married, they say, "Oh, ako legal, ikaw illegal," and they're referring perhaps to maybe the concubine or the other party, or they talk about those instances when yung nagsasama-sama lang na hindi nag-asawa talaga. So there's that distinction in the Philippines, both in law but also in terms of the cultural expectations. In Australia, though, there's no such thing. Okay, in general, we can understand that the rights of people who are married, as well as the parties who are in a de facto relationship, are generally the same. Okay, I think one of the main differences, though, and this may have an implication as far as visa applications in Australia is concerned, is that there's a question about proving the relationship. If you are married, then it's easy to show that you've got the marriage certificate to establish that you are in a genuine and legal relationship. But if you are in a de facto relationship, then you might need greater proof to show that you are in fact in a genuine and long-term relationship. So that's mainly one of the main differences there. And in Australia, for example, as far as what is considered to be a de facto relationship, under the law, it is a relationship as a couple living together on a genuine domestic basis. But as I mentioned, generally the rights are the same. Now, one of the other differences between Philippine marriage or de facto relationships and that of Australia is that in the Philippines, only a man and a woman legally can be married or can live together. And when a man and a woman live together, meaning they have a de facto relationship, some rights emanate and emerge from that relationship. Pero kung puro lalaki at puro babae ang nagsasama na parang nagcohabit sila, well, parang no rights will emerge under Philippine law, because we don't accept those kinds. Well, the Philippines does not accept those kinds of relationships. In Australia, though, it doesn't really matter whether it's male-female, male-male, or female-female, same-sex. We have same-sex marriages and same-sex relationships, and these are all legal and legitimate in Australia. Now, in terms of property relations, under the Family Law Act of 1986, when when parties, again, a man and a woman, get married in the Philippines, then unless there is a what is known as a marriage settlement, a formal agreement that parties enter into prior to the solemnization of the marriage, unless that exists, if that does not exist, then the Family Law Act provides that the parties enter into what is known as an absolute community of property. What it means in an absolute community of property is that all properties that the partners acquire during the marriage, are owned equally and jointly by the parties. But at the same time, even properties acquired by the parties prior to the marriage also belong to the absolute community of property. So in other words, under Philippine law, if you were married, after 1986, meaning after the Family Code took effect, Family Code of 1987 took effect, what it means is that inheritances, if you had an inheritance during the course of the marriage, which you acquired, that belongs to the absolute community of property. Prior to that, for those people who are married prior to the effectivity of the Family Law Act of 1987, it was the conjugal partnership of gains which applied. And I'm not going to go into the details because it might just be confusing. So as far as marriage relationships are concerned, that are governed by the Family Code of 1987, you have the absolute community of property. For those who are in a de facto relationship in the Philippines, then there is co-ownership, which are again a different set of rules because the ownership only the co-ownership applies to properties acquired by the parties in the course of their de facto or cohabitation relationship. In Australia, what is crucial is that parties can actually enter into what are known as binding financial agreements prior to the relationship or even during the relationship or even at the time that the relationship is ended. So they can enter into what is known as a binding financial agreement. In the Philippines, the only time you can try to make a disposition or enter into an agreement about property matters will have to be prior to the solemnization of the marriage. Not in Australia. You can have a binding financial agreement anytime before, during, or at the time that you end the marriage. You can also have an informal agreement. You can also seek consent orders. I'm not going to spend time on property relations because it's quite a very complex matter, except to point out to you that in the event in Australia, it's possible to enter into a binding financial agreement, which must be in writing, and there is a requirement that each of the parties must seek independent legal advice. It's also crucial for the solicitors to have signed off on the written financial agreement in order for it to be binding. Meaning, if it's binding, it's something that both parties will have to follow and observe, and it can be enforced in court. Okay, so we've covered rights, we've covered parties, we've talked about property relations. Let's talk about applications for financial order. So, because there's quite a very small distinction in Australia when it relates to parties who are either married or in a de facto relationship. So, going back to Australia, what it means is that usually when you have parties who are married in Australia or who are in a de facto relationship, and then the relationship has come to an end, either because they've had a divorce or because they've decided to separate. Okay, so when that happens, and then assuming that they have properties, and they usually do because they may have superannuation, they may have bought some properties, they may have cars and so on, and then usually there are debts and liabilities and so on. So what the parties can do is that they can enter into an informal agreement, meaning they just agree, okay, you get this, you get that, or they can enter into a binding financial agreement. But in the event that they can agree, assuming they cannot agree on how to settle their property relations, both in terms of the assets and the liabilities, then they may have to go to court to apply for financial orders. At the moment, what the court that it will be involved is what is known as the Federal Circuit and Family Court of Australia. It used to be that these were separate federal courts in Australia. You had the Federal Circuit Court of Australia, and then you had the Family Court of Australia. But in 2021, or was it 2020, there was an amalgamation or combination of the two courts. So you now have only the Federal Circuit and Family Court. So that is a federal or a Commonwealth court that applies to that will have jurisdiction when parties or a party applies for financial order. So one of the notable distinct differences would be that if there's an application for a financial order and it relates to a relationship where the parties have been married, then it is important that the application for financial orders must be applied for within 12 months of the divorce becoming final. And I'm going to be talking about divorce in a short while as well. If it's a de facto,
Manjo,
yes,
Manjo, I'm sorry. If I could just cut you
Sure.
from that point before you go further, because I think there are questions now from our audience.
Okay.
So
Okay,
first,
mabilis mo ko masyado magsalita or
no,
yeah.
it's very good. No, it's all
Okay.
clear. I just want to pass this, very important aspects ng
Yep.
discussion mo.
Mhm.
Baka makalimutan mamaya.
Okay.
Now, some people are asking, because you mentioned about the binding financial agreement that they can do before, during, at any point of the
That's right.
relationship. Ano?
Mhm.
Is this the same of the prenuptial agreement that we have in the Philippines?
Well, in a sense, yes, but
Hmm.
so what we call, the prenuptial agreement or the marriage settlement in the Philippines, the rule there is that the prenuptial agreement, as we call prenup, it has to be prior to the solemnization of the marriage. Okay. Otherwise,
Okay.
the moment the parties are married, they are no longer free to agree on how they may make arrangements in relation to their property. That is governed by the civil code.
And then everything will be community, or yung sabi mo kanina, the absolute
property.
community of properties. Yeah.
Assuming that the parties are married after the effectivity of the family code in 1987. Otherwise, it's the conjugal partnership of gains. In Australia, the parties can enter into what is known as a binding financial agreement. And in fact, the Family Law Act encourages parties to enter into a binding financial agreement.
So it doesn't only happen, because I usually hear, couples in Australia that, okay, because we're divorced, we're going to get our binding financial agreements. It doesn't usually work that way. So it can be done before, during, or at any point of the relationship.
That's right.
All right.
The crucial point there is that it must be in writing if it's going to be binding. I mean, you can have an informal agreement, pero kung yung parties want a binding financial agreement, it has to be in writing.
Yeah.
We must have consulted independent solicitors. So dapat bawat isa would have an independent solicitor, and the independent solicitor would have signed off the binding financial agreement. Otherwise, it cannot be enforced in court.
Okay. Now, John Paul Garcia has a question. Ang question niya is, what if engaged pa lang po?
Okay.
Then planning to go on tourist visa in Australia with Australian national. Is it possible po ba? Naku, ano kaya ang ibig niyang sabihin? Teka muna, Paul. Pakiklaro ng kaunti yung question mo. Parang hindi yata malinaw. That is why I don't want to go further, kasi nawala na sa context siguro. Ang tanong niya, what if engaged pa lang? And then planning to go on a tourist visa in Australia with Australian national. Is it possible po ba? I think what John Paul is asking is, can they actually get married? Ganun ba yun? Can they actually get married or do something already? Say, for example, this financial binding agreement once they are in Australia. Pero hindi pa sila married, engaged pa lang sila. That is what he is asking.
Okay. There are two aspects to that question. There's such a thing as private international law or conflict of laws. Before I answer that question, mainly because if you're a Filipino coming to Australia on a tourist visa, you're still a Filipino citizen, right? You come to Australia, you're not an Australian citizen. And you begin to wonder what laws will actually govern.
The jurisdiction issue, right?
If you want to get married, what happens, and so on. I was going to touch on that. So under Article 16 of the Civil Code of the Philippines, laws relating to family rights and duties apply to Filipinos either in the Philippines or even those living abroad under Article 16. So if you're a Filipino citizen, wherever you go, Philippine laws will apply, the substantive laws of the Philippines. So I'm just
does follow them.
Yeah, so laws relating to the solemnization and formality of wills and validity of wills, laws relating to whether or not you can actually get married will still apply to a Filipino going to Australia. So for example, if you were married in the Philippines, and we're dealing here with Filipino citizens, and you come to Australia marrying somebody else, under Philippine laws, that marriage is going to be void. Because even if you were successful in securing a divorce in Australia, that will not be recognized by Philippine laws. Now, of course, at the end of the day, it doesn't really matter if you decide to continue to live in Australia and you have no plans of going back to the Philippines anyway. It wouldn't matter. But if you were married in the Philippines and somehow you couldn't get the marriage to be avoided, in other words, there was no declaration of nullity of marriage under Article 36 of the Family Code, or it wasn't one of those marriages which are considered void or voidable under the Civil Code of the Philippines, then you are still validly married in the Philippines, even when you go to Australia, even if you separate. So your problem there is you're a Filipino citizen separated from your wife or from your spouse in the Philippines, but there is no, the marriage hasn't been declared null and void. You go to Australia, get divorced, and then remarry. If you were to go back to the Philippines, there will be a problem because Philippine law will not recognize your divorce in Australia, and therefore it will still be Philippine law which will apply. So if you had properties in the Philippines, chances are Philippine law will apply because of Article 15, that when it comes to property matters, it will always be Philippine law that will apply to properties in the Philippines. Of course, it will be different in Australia because it will be Australian law will apply. So that's why it's known as conflict of laws, or what is known as private international law. Now, I think part of the question of, what was his name?
John Paul.
John Paul, that may have had something to do with getting married, was it? Or was it about private relations?
Maybe he's thinking of getting married,
Of getting married. Well, two aspects there. One's the legal aspect. The other one is the what you might call, the practical one, because it's really not common among Filipinos to enter into a financial agreement or a prenuptial agreement prior to getting married. Like parang masyado kang naninigurado. Unless you're marrying Sharon Cuneta or somebody rich, or maybe somebody with children and or one of their spouses mayaman na talaga, then it makes sense. But sometimes among Filipinos, you go abroad and then you sign a prenuptial agreement prior to getting married. Parang ang daming nagtanong kaagad, parang may problema. And I'm not saying that's wrong. I'm just saying it's not common in the Philippines. It's probably more common in Australia.
So if we're going to make it clearer, so two Filipinos who come to Australia, they're not married in the Philippines, can actually get married in Australia. No problem at all.
Yes. So if you have two Filipinos coming to Australia and they get married in Australia, and assuming there are no legal impediments in the Philippines,
and that marriage will be recognized in the Philippines.
Marriage will be recognized in the Philippines as valid. It will be valid both in the Philippines and in Australia.
Now, what if, say, for example, two Filipinos married in the Philippines?
Assuming male and female yan, ha?
Yes.
Okay.
So married couple, they got married in the Philippines, they come to Australia, they live in Australia, file the divorce, and then the divorce was approved by the Court of Australia. Yes. Will that carry over to Philippines, or will they need to have some sort of judicial recognition or another process to do?
No. So if you have, assuming they're both Philippine citizens still, at that time, they were able to secure a divorce in Australia. The divorce in Australia will be valid and enforceable in Australia. But that court order of divorce will not be recognized in the Philippines because the Philippine laws do not recognize divorce in the Philippines or in any jurisdiction abroad. So what it means is, and this is an important point. I was going to be talking about adultery, okay? This is a crucial point because if you have two parties who who were married in the Philippines, and as just pointed out, they went to Australia, they then divorced in Australia. The divorce is married in Australia. Let's assume that the woman goes back to the Philippines. Okay, the woman thinks, oh, I've been divorced in Australia. Uy, may nakita akong gwapong lalaki or maginoo, magpapakasal ako sa kanya. So remember, in Australia, single siya doon kasi nag-divorce. Bumalik siya sa Pilipinas. In fact, bumalik siya sa Pilipinas, nag-asawa siya sa Australia, bumalik siya sa Pilipinas kasama yung bago niyang asawa na pinangasawa niya sa Australia. Ang question ngayon, so meron silang ginawang maganda o hindi maganda sa Pilipinas, which we might call adultery. Well, we call it an adulterous relationship.
Yep.
The woman and the man would have committed the crime of adultery in the Philippines. Okay, so that's one of the problems there.
Yep.
Of course, in Australia, there is no adultery in
Yeah,
Australia.
that's what I wanted to ask, Majo. So if we're going to reverse it, because I have been in contact with some couples na they're married in the Philippines, they are here as a couple, but then suddenly the other or the wife had a relationship with another person. So
Australia.
ang hinihingi, yes, ang hinihingi niya is remedy kasi nga wala namang adultery dito. So saan siya pwedeng magreklamo in that aspects, and ano yung pwede niyang gawin?
Dapat
Kasi
magreklamo
syempre
siya.
masama yung loob niya, no?
Magreklamo siya sa tatay ng babae. Wala siya magagawang iba eh. Because it's not a crime in Australia. It's, you know, you can do that in Australia. It doesn't really matter. Wala kang magagawa.
But they can file. They can file a
sorry.
case in the Philippines.
Absolutely
Can
not.
he file
No,
a case
they
in the
cannot.
Philippines?
They cannot.
They
They cannot file, assuming that yung babae na, you know, had sexual relations with a man who was not her husband, but it happened in Australia. So we're talking of a married woman who had sexual relations with a man who was not her husband, but it happened in Australia. The Filipino husband cannot file
Adultery case.
an adultery case in the Philippines because criminal laws will only apply in the Philippines. It doesn't apply extraterritorially.
Oh, right.
You cannot apply Philippine laws on adultery in Australia. The Philippines does not have jurisdiction.
Yep.
Okay.
Yeah. Wow,
magagawa.
that's very interesting, Manjo. Ako, may mga nakikinig na sa atin and dumadami yung mga questions natin. That's very interesting because I have actually been talking to some couples in the last few weeks. They have exactly the same problem. And dahil syempre masama yung loob, sa Pilipinas kasi nalalabas nila yung sama ng loob nila sa galit by court o kaya by any other things. But in here, they can't do anything. So I said, oh, well, I'm not a family law expert in that area. So maybe some of them are listening tonight. But anyway, just to touch on some more questions. Nako, sandali, Manjo, I think we will have to entertain these questions now.
Let me just touch on a point. Yeah, sure. But let me just touch on a crucial point there as well.
Yep.
In the Philippines kasi, you know, when assuming nag-asawa, di ba? At gusto nilang maghiwalay. And I'm not talking about hiwalay as in legal separation. I'm talking about hiwalay in the sense na naputol yung marriage bonds. Okay? The best course of action to take in the Philippines is what is known as doing it through Article 36 of the Family Code, meaning declaration of nullity of marriage. Okay? That's really the only way by which a party can terminate the marriage ties in the Philippines. In Australia, we have what is known as the no-fault divorce. In Australia, therefore, married couples can divorce without any reason, without walang ground. You don't have to talk about adultery. You don't have to talk about anything. If you disagree, you just decide to walk away from it, you know, from the marriage in Australia, apply for divorce because of no-fault divorce.
Correct. Yeah, that's why I said it's very ugly in the Philippines when it comes to separation. And even if you take a remedy before legal proceedings, it's still ugly because of the grounds for legal annulment, the grounds for separation. You have to dig all those dirty about the other party, and only to prove that he had done a lot of evil things during the relationship. But in here, you don't need to prove all those things, right? If you can't really live together, can't really be in each other's company, then just walk away and file a divorce. That's what it is. Now, okay, Manju, I hope you don't mind. We have more questions coming up. So from Andui Pruni, now we are doing Taglish here. So
How many participants are there, if I might ask?
At the moment, we have 13 viewers at the moment, and a lot of them are actively participating.
Okay.
Now, Andui Pruni is asking, Ma'am, for example, me and my Aussie citizen BF married in the Philippines, is it automatic for me to have an equal rights regarding like money and lots of my husband? So I think Andui Pruni is asking, basically what she's asking is if they get married, do they have equal rights in terms of money and lots and properties, I think, with her husband? Okay. Assuming that they are here in Australia, I think.
Assuming that they go back to Australia.
Yep.
Okay.
And she's marrying an Aussie citizen.
Okay, so let's talk about rights first. So I assume that when it comes to the question of rights, we're not talking of rights in relation to Centrelink or rights in relation to being able to vote. So hindi yung pinag-usapan natin, di ba? Because for one to be able to get access to Centrelink benefits or Medicare benefits or being able to vote, you need to either you need to be an Australian permanent resident, or being able to vote, you need to be an Australian citizen. Pinag-usapan siguro natin is, meron ba akong karapatan sa mga pag-aari ng aking napapangasawa, or in terms of the properties or assets we're able to acquire during the marriage? The answer is yes. The answer is definitely yes. As far as the Family Law Act is concerned, when at some point the parties decide to end the relationship, or one of the parties at some point dies, then what the court does is to look at the respective contributions of the parties into the relationship. What have they contributed in terms of superannuation, salaries, blah, blah, blah. And then they factor in as well. It's said when you speak of contributions, hindi lang yung contribution in terms of monetary or financial, but even in terms of time, because somebody took care of the family, somebody took care of an ailing family member, and so on. So kasama yun sa mga contributions, which is counted by the courts. But at the same time, the courts will have to take into account deductions or liabilities for debts, whatever. But again, so as I mentioned, there certainly would be rights involved, but when it comes to splitting the assets, there are at least 2 points by which the assets could be split. One is when the parties decide to end the relationship, or when one of the parties dies. So in that case, the assets or the properties that belong to the parties will then have to be severed.
Yep. So I think that was it. But the gist of the question there is it automatic for her to have an equal right? So I think in your answer, you're saying no. You have to actually determine the contributions.
No.
Of the other party as well.
No, it's not going to be like that. In the Philippines, kung nag-asawa kayo and you're governed by the absolute community of property, actually sa Philippines, kung meron kayong properties na doon, automatic yan 50-50. Kahit na yung one of the parties walang ginawa, natutulog lang at wala talagang ginawa, automatic yan, 50-50 yan, under the absolute community of property regime in the Philippines. But if we're dealing with assets or properties in Australia, that's not automatic, because if it comes to the point where one of the parties dies, or they separate and then they have to go to court to apply for a financial order, the court really will have to examine the respective contribution of the parties. Contribution, as I mentioned, looked at in a broader sense, not just contribution monetary or economic or financial, but contribution to the relationship itself. So for example, one of the partners may decide to stay in the house, mag-alaga, take care of the husband or whatever, or take care of the wife, while the other spouse goes out to work. That's contribution enough, or taking care of the children, etc.
That's correct. Yep.
Okay.
Yeah. All right. I think that's very clear now. But then, dun sa mga same-sex relationship, if pero parehong Filipino or Filipina, and they got married here. Will they enjoy that automatic 50-50 arrangement or 50-50 rule, or no, not at all, because
No, no,
there's no
remember in
same-sex marriage?
Australia, there is no such thing as automatic 50-50 rule in Australia. Okay. It's all about, what was the respective contribution of the parties. So in Australia, therefore, even if it were male or female, or even male female, doesn't really matter. The law is always about what was the respective contribution of the parties. But that's assuming somebody dies, or that's assuming the parties go to court. Because if they enter into a formal arrangement, or they enter into what is known as a binding financial agreement, then there is broader scope as to how they may divvy or divide the assets of their relationship. As far as Philippine law is concerned, that's a different matter, because the Philippine law will never recognize the validity or legality of same-sex relationships. Never.
Okay. All right. So I think we will need to go to divorce now. So unless there's John Paul has a question as well, pero medyo mahaba. And
if you will allow me, kasi medyo marami PowerPoint ko, ma-miss out
please.
ko. I'll keep on going. I think some of the questions will likely be answered as I move along.
Yep.
Because I was hoping to talk about divorce in Australia. I was going to talk about child matters. I was going to talk about child support agreements and so on. We're going to talk about domestic violence, etc. So medyo malayo pa tayo. So I'm just going to move along, and if you manage to hold on to the questions, that'll be better. So as I mentioned, we're now talking about divorce in Australia. There is no divorce in the Philippines. If Filipino citizens divorce in Australia, that divorce will not be recognized in the Philippines. No Filipino citizen can apply to the court to seek the enforcement of the divorce order. That will not be allowed. Okay. Now, so in Australia, though, because we have what is known as the no-fault divorce, people can just apply for divorce for no reason. There is none of the parties applying for divorce in Australia has to provide a reason. The only requirement is that it must be shown that the parties have separated for at least 12 months. Now, there will be instances when the parties separate in the sense that they've agreed to separate, but they continue to live in the same house for whatever reason. The courts will still consider that as part of the separation, for as long as there was, in fact, true separation, even if they live in the same house. So none of the spouses in Australia will have to prove anything as to the cause of the breakdown. The court is not interested in that, and the law is not interested in that. The only way whereby a party, so in other words, when one of the parties has applied for divorce in Australia, there is no way for one of the parties to oppose the divorce application. You probably hear stories in the US, mga pelikula, sinasabi, kailangan mag-usap tayo, you need to pay me to pay that so that I don't object to your divorce application. There is no such thing in Australia. The moment that the parties have separated for 12 months and one of the parties has now applied for divorce, that divorce application cannot be stopped. The only basis for opposing a divorce application is to establish that the parties have not in fact separated for 12 months. Yun lang. Because there is a jurisdictional requirement that for a divorce decree to be issued by an Australian court, which is the Federal Circuit and Family Court of Australia, the parties must have separated for 12 months. So yun lang that's the only way. Okay?
Yeah.
Yes.
Yeah, thanks for that, Manjo. Actually, well, some people would think that, okay, I need to find reasons. I need to have some grounds, thinking that, the Philippine grounds still apply in Australia. So that's very clear. Okay, so Manjo has explained you don't need to be, and especially for those people who are staying in a very bad relationship, thinking that, okay, hindi pa naman grabe yung kalagayan ko, so I can't stay. No, it's a no. So hindi kayo nakatali dun sa ganong klaseng relationship. Yeah. So 12 months separation is a thing that you need to be meeting. But as Manjo said, hindi nyo kailangang magkahiwalay physically kasi merong mga instances that you are separated but living in the same roof. But there are other things that you need to do to prove that. Okay, so yeah, if you have questions about divorce, this is your chance to put your questions. And Manjo will move along so that we
So
can.
let me also point out that when the parties separate, maraming implications yan. One is they may decide to apply for divorce. They may want to settle their property relations, meaning merong financial matters, and there might be care arrangements pertaining to the children, right? These are all separate legal proceedings. So if you apply for divorce, that's a divorce application. It has nothing to do with financial matters or property matters. That's a separate application with the same court, but it's a separate application together. When it comes to care arrangements for children, again, that's a totally separate application. So in other words, in the Philippines kasi, if the parties somehow, separate and they apply for legal separation or they apply for declaration of nullity of marriage under Article 36 of the Family Code, which is the usual go-to way by which parties separate, magkasama lahat yan. Kasama na yung property relations and custody of children. Isa yan sa Pilipinas, not in Australia. These are three separate legal matters or legal proceedings or legal applications.
Yep. Okay. That is right. No? Kaya it's so beautiful in Australia. No? So if you can't really live with another person, you don't need to stay there. About the financial, that can be resolved even after the divorce, pwede rin. No? Hindi kailangan pagsama-samahin at hindi kailangan sabay-sabay. Because there are other matters that can be resolved in its own time. And okay, so yeah.
Okay, I'm just gonna move on now because
yes.
I need to leave at 6:45. So who can apply for divorce? I mean, obviously, if you're an Australian citizen, you can apply for divorce. But ang pinag-usapan natin dito, paano kung turista ka, kararating mo lang sa Australia, you're probably here on a student visa, or you're probably here on a partner visa or whatever, and then gusto mo na mag-divorce, but you're a Filipino citizen. But you've only here on a kind of a temporary basis. Can you still apply for divorce? Yun ang palaging tinatanong, di ba? Well, you can apply for a divorce in Australia if either you or your spouse regard Australia as your home and intend to live in Australia indefinitely. So meaning, one of the jurisdictional questions for the Federal Circuit and Family Court, or you're an Australian citizen by birth, or you ordinarily live in Australia and have done so for 12 months immediately prior to filing for divorce. So so in other words, even if you're a Filipino citizen, you can apply for divorce for as long as you meet any of these conditions. Okay, so
that's clear.
Now, so pinag-usapan na natin we've touched upon rights of the parties. We've talked about property matters. We've talked about divorce. Let's talk about domestic violence. So, well, in many cases, naghihiwalay ang mag-asawa or yung mga kapatid o mga partners because they've fallen out of love or they want to move on or whatever. Okay. But sometimes one of the main reasons why the parties break up is because of the presence of what is known as domestic violence. Well, sa Pilipinas, parang walang domestic violence, di ba? Kasi, which is really bad, which is really sad. Parang it's almost accepted in the Philippines na ginugulpi mo ang asawa mo, okay lang. Or you force yourself upon your wife, okay lang. Although by now it's illegal in the Philippines as well. No? You can't rape your wife in the Philippines anymore. But in the past, or even culturally, almost accepted practice na yan. Okay lang yan, itago mo yan. Not in Australia. I mean, in the Philippines, you could probably get away with it, but not in Australia. So domestic violence would be any instance when one of the parties, when I say parties because they don't have to be married, okay, they could be in an intimate relationship, they could be in a de facto relationship, it can even apply to family members. When one of the parties tries to control or dominates another person and causes fear for the safety and well-being. So maraming klaseng domestic violence, of course, the most common would be physical abuse. Ginugulpi, sinasampal, pinupush, or whatever. No? But that's physical violence or physical abuse. Merong sexual abuse. Unreasonable demands or being asked to do whatever na hindi naman gusto, that type of thing. There could be emotional or psychological abuse. Yung minumura palagi, domineering, minamaliit, sinasabihan ng masama. Those are examples of emotional abuse. There could be psychological abuse in the sense na hindi naman siguro tinatamaan, but tinatakot, whatever. There's also economic abuse in the sense na one of the parties controls the way that the other spends money, or it says na pag may sweldo ka or may income ka, akong may hawak, bibigyan kita ng ganito lang. So in other words, as a way to control the other party, that's economic abuse, threatening behavior, coercive behavior, pinipuwersa. So coercing in many ways, maybe to do chores, to go to church, whatever. Pero yung pinipuwersa na. So those are all forms of domestic violence, and they are not permitted in Australia. I need to be clear, when I speak of domestic violence right now, and I talk about domestic violence orders, this is only in the context of Queensland. Other states in Australia and other territories like the ACT will have their own state laws or territory laws pertaining to domestic violence. I'm mainly speaking of Queensland domestic violence laws. So one thing that I need to point out is that essentially earlier, when we talked about marriages, we talked about divorce, we talked about property relations, and we'll be talking about children, for example. All of these matters are actually governed by what are known as Commonwealth or federal laws, or these are Australian Commonwealth, Australian federal laws. So it's at the federal level, so that you often see Family Law Act 1975 Commonwealth, or you might have the Child Support Assessment Act Commonwealth. In other words, these are federal or Commonwealth laws. These are laws which have been passed by the Commonwealth Parliament. But there are certain laws which can only be legislated by the states. I don't want to go into constitutional law, which is actually a subject I teach in Australia, but all other subjects which the Australian Commonwealth Constitution of 1901 has not given to the Australian Commonwealth Parliament, these are retained by the states. So when it comes to domestic violence, for example, that is not a subject that the Australian Commonwealth Constitution has given to the Commonwealth Parliament or the Australian Commonwealth Parliament. So in other words, it's the respective states that legislate or enact laws pertaining to domestic violence. So we have our own domestic laws in Australia, in Queensland. So let's just talk of what domestic violence might mean more. So as I mentioned, when we talk about domestic violence, it doesn't have to happen only in relation to yung mga mag-asawa. It can happen to de facto relationships as well, but it can also happen in relation to parent and child. It can happen to relatives, brother, sister, grandparent, aunt, uncle, and so on. These are still covered by what is known as relationships which can trigger the domestic violence laws in Queensland or in other states. There's even the informal care relationship. So one person who is or was depending on another person for help with daily living activities, that will still be covered by what is known as domestic violence legislation. Now, assuming that there is domestic violence, okay, what can we expect? Now, it's unfortunate, and it's quite common. It's unfortunate that we've seen in the news so many instances of domestic violence cases, leading to certain, usually wives, who end up getting killed or severely injured at the hands of their husbands or their partners. It's really terrible. So I'd like to point out that if you are in a situation where you feel threatened or your safety is threatened as a result of what I've discussed to be domestic violence, you should be ready. You should take care of yourself and be prepared to go to the police if need be. And I'm going to be talking about temporary police protection notices in a short while. I'll also talk about temporary protection orders and so on. But what typically happens is that if there is evidence of domestic violence, a party can apply for a domestic violence by himself with a Queensland Magistrates Court. You noticed earlier we're talking about the Federal Circuit and Family Court, which is a federal or Commonwealth court. But if you're talking about applying for domestic violence order, you apply with the Queensland Magistrates Court. You can apply for it on your own, or it can be through the police. So if there is a domestic or a family violence incident and the police come, then in all likelihood, it will be the police who will apply for a domestic violence order on behalf of the aggrieved or the one who suffered or experienced domestic violence. It will be the police who applied for that. But sometimes, it's difficult for one of the parties to call the police because there is no evidence. If it's all about threatening behavior or coercive behavior, the police likely won't intervene because there is no evidence, right? andyan yung police kung, may tinamaan na may nabasa, ganyan-ganyan. Klarong ebidensya, the police will probably intervene. But in most cases, a lot of what goes on behind, the homes and where there is domestic violence is not really seen by the public, which is why in many cases, the people who are, offenders or violent people, they may appear in the community to really be nice, na parang, bait ang tao, nagsisimba palagi. It can't be him. But we don't really know what's happening, right? So in many cases, therefore, a lot of the, well, not really a lot, but there will be several instances where the aggrieved, the one who suffers domestic violence, will have to apply for a domestic violence order on his or her own. It's important to remember that when there is an application for domestic violence order, what the court will do will be, on the basis of the application for a domestic violence order, the court can be convinced that a temporary protection order should be issued. It's called temporary, so temporary lang. But that temporary can be 1 year, even 2 years sometimes, because the legal proceeding can drag on. But what it does is that the domestic violence order, which is usually temporary at the beginning, which can be final at the end, what it does is to order the respondent, the one who commits or is suspected of having committed domestic violence, to behave, to conduct himself in a good manner, behave well in relation to the aggrieved or any other persons in the domestic violence order. Kasama doon will be instructions like, you cannot go near this person within a distance of about 100 meters. You cannot disparage this person. You cannot communicate with this person. You cannot approach the person, the aggrieved party's workplace, and so on. So these are some of the conditions. It can happen, however, that the parties, despite the DVO, will continue to live in the same house. Because hindi naman automatic na porque merong DVO na inisyo yung court, that the other party is ejected from the house. It doesn't follow, okay? Especially if, both parties own the house or both parties have the same rights to the house. So it's not automatic. What it only means is that if a DVO has been issued against a respondent and they happen to live in the same house, the respondent will have to behave well in relation to the aggrieved. That domestic violence order does not mean that there has been a criminal offense, okay? But if the respondent violates the domestic violence order, it can become a criminal offense. In which case, if there is a violation of the DVO, what the aggrieved should do should be to go to the police. Magrereklamo sa police, because when that is brought to the attention of the police and the police believe that a breach of the domestic violence order has been committed, they can file a criminal complaint with the court, and then that becomes a criminal offense. Okay, may questions ba tungkol doon? Nakamute ka, Tess.
Manjo, we have a questions about the about coverage of domestic violence. No, I heard you mention about your own partner being subjected to domestic violence. Pero how about the boyfriends and the girlfriends? Because there's a question here. For example, from Andoy Pruni, she said, for example, if you are on a tourist visa or you are a tourist visa holder and you live with your Australian citizen boyfriend and then he physically abused you, is there any resort? Is that covered by domestic violence?
Yeah, you will note there's a question on they live together.
Yeah.
Right? The fact that they live together means they are in a de facto relationship. Therefore, they are in an intimate relationship. Therefore, they are covered by domestic violence order laws. But kung they're just boyfriend and girlfriend, but they're not living together, then the courts cannot issue a DVO. I mean, you can always apply for something else on the basis of a crime that's probably committed, like stalking, perhaps, but it will not fall within the jurisdiction of the court as far as the DVO is concerned, unless merong de facto relationship.
Yeah, I think, Manja, there's a lot of confusion about the living together. Is there any qualification on that? Do you have to be with your boyfriend? Because for Filipinos, it's they confuse themselves about distinguishing their relationship into boyfriend, girlfriend, de facto, or whatever. But is there any qualification that we can actually put in there? Say, for example, I'm with him 2 days a week and 3 days from here, or we just see each other, on important occasions. Because I find Filipinos having confusion about the boyfriend, girlfriend, de facto relationship. They can't just put a mark. Where does it how can we differentiate the two? So maybe to make it clear to them.
As far as Australian law is concerned, there is a definition of what is known as a de facto relationship. It says it's a relationship as a couple living together on a genuine domestic basis. Walang time frame. For as long as you agree to live together, you might have been living together for a week or 2 weeks. If you can establish that that relationship is genuine, you're living together as a couple on a genuine domestic basis, then you are in a domestic relationship. So there is no time frame.
Okay, so which means to say that if they live together, they should probably refrain referring to the other party as their BF or GF because they are partners.
I mean, that's a different thing. Bahala, they can call each other whatever, right?
Yeah.
But as far as the law is concerned, in Australia is concerned, they are in a de facto relationship.
Yep.
The other thing I'd like to point out is that when it comes to de facto relationships in Australia, you don't have to register it, but you actually could register it as a de facto relationship. So you can take that next step of registering your relationship as a de facto relationship, just to be able to clearly establish that you are in fact in a de facto relationship. Down the line, that may be important for the purpose of being able to establish that you are in a de facto relationship. Otherwise, if there'll be questions of were you in fact in a de facto relationship, you need to show evidence like bank statements, common expenses, blah blah blah.
Correct. Yeah, because in Migration Act, when you say de facto relationship, you have to prove the 4 aspects of relationship. So the financial, household, social, and commitment to each other. So the confusion there is, when are you going to call your other, the significant other, as your boyfriend or girlfriend? Now you have to meet those 4 aspects of relationship as well. So the definition is very important. This is confusing. Why? Because it has a lot of impacts on your everyday life and of course on your rights, no? Kaya minsan covered ba ako ng domestic violence kung BF ko lang siya, something like that. So you really have to really think it through and then fall into specific space na mahirap yung nagfo-floating ka, you don't know kung anong kalagayan mo or sitwasyon mo. But anyway, so Fiore has some insights here. So Fiore said that I thought domestic violence in Queensland has now been criminalized. Now in the past, unless the person with DVO breaches the order, he or she will not have a criminal history. But now DVO has been criminalized. That is why DV applications, especially by Filipinos without PR or non-residents, take ages before it is resolved. Many of those I handled during COVID ended up in settlement outside court.
Okay, let's clarify that. Usually when there is an allegation of a crime, meaning it's really a police matter, if the court finds, well, there are 2 aspects to it. It could be by the judge or it could be by jury. But let's assume that it's a court proceeding. If it were a criminal matter, what happens then is that the court will issue judgment to penalize the offender, unless it can be a conviction without being recorded. The DVO today, as far as I know, is still not a criminal offense. You can have you can commit domestic violence. It still is not an offense. It becomes an offense only when you breach a domestic violence order. That is not to say that you will not be asked questions in a visa application whether or not you've committed domestic violence or a DVO has been issued against you, because typically I think when you apply for a visa in Australia or permanent residence or whatever, there will be a question that will be asked whether or not you have been the subject of a DVO application. But it is not a crime per se. If you commit domestic violence in the sense that you threaten somebody, you've hit, well, let's not talk about hitting because that can be assault in under the Queensland Criminal Code. Pero may minumura ka, tinatakot mo siya, you control the financial aspects of a person. So these are examples of domestic violence, right? So therefore, a domestic violence order may be issued against that person. When the domestic violence order is issued, that person did not become a criminal, or an offender. That person simply has been the subject of a DVO. So it's So domestic violence order is not covered by the Crimes Act in Queensland. It's not. It's still just a civil proceeding, except that the moment that the respondent breaches a domestic violence order, then that becomes a crime or an offense, subject to penalties.
Okay. Yep, that's very clear. Okay, so moving on, because I know you'll be leaving in a few minutes.
Yeah, okay.
Yeah. Wait.
So moving on, so it's a criminal offense. This will not appear in the respondent's criminal history. What can also happen, and this has something to do with the DVO. Remember, when somebody has experienced DVO, it's often possible that there's an interaction between civil laws or administrative laws and criminal laws. Like yung ginulpi, syempre DVO yan, di ba? But at the same time, assault has been committed. In fact, there's the tort of battery that has been committed, another civil aspect. So what can happen is, if the police go to a household or to an incident where there is domestic violence, kasi may nagulpi or may nasugatan as a result of domestic violence, the police can issue a police protection notice to the respondent, because that's where the police have intervened. It will not require the respondent to be of good behavior and not commit domestic violence. And then it may also prevent the respondent from contacting the aggrieved or coming within a certain distance of premises for 24 hours. So it's a short period of time, yung police protection notice. I think the AVO, the Apprehended Violence Order, I think in New South Wales and Victoria, are for a longer period of time, but in Queensland it's only for 24 hours. However, if the police believe the aggrieved is in immediate danger, they can take the respondent into custody for up to 4 hours. So ito, meron na rin kasamang crime nangyari dyan, kasi maybe may assault, no? Which is a criminal offense. But remember, domestic violence orders, domestic violence by itself, kasi nga sinasabi mo gago ka, PI ka, or bobo ka, blah blah blah. Domestic violence, yeah, because that's that's abuse, but that is not a crime. Okay, the police will not even likely to intervene, because the police will only intervene if there's imminent danger or there has in fact been physical injuries sustained by an aggrieved. Okay, so I'll just move on. So it's also possible, therefore, that the police can issue a police protection notice, but at the same time, they may decide to file criminal charges against the respondent. What will then happen is, because the police protection notice is for a very limited time of 24 hours, the police will apply for a temporary protection order on behalf of the aggrieved. When that happens, the aggrieved does not even have to go to the Queensland Magistrates Court, because the applicant is the police, and it will be the police presenting evidence on behalf of the aggrieved to the court to convince the court to issue what is known as the temporary protection order, or at some point a final protection order, assuming that the respondent contests the allegations about domestic violence and they probably have to go to trial. Okay, moving on. Oh, I need to leave in 4 minutes. So let's quickly go through this, because I need to go in 4 minutes, sorry. So let's assume na naghiwalay may mga bata. And when it's may bata, we're talking of children below 18 years old. Parehas sa Pilipinas, okay? Sa Pilipinas, pinag-uusapan natin doon custody arrangements. Sino may custody sa bata? Hindi pinag-uusapan yan sa Australia. There is no such thing as, it used to be, but under the Family Law Act of 1975, binago na yung expectation, so that we no longer talk about parental rights, but parental responsibilities. Time we're meeting him at 7:15. So as far as the Family Law Act of 1975 Commonwealth is concerned, when the parties have to go to court to apply for what is known as parenting orders, the courts will always consider or have regard to the best interest of the child as its paramount consideration. So pinag-usapan palagi what is for the best interest of the child, not the best interest of the parent. Of course, that's also the same formula in the Philippines, right? Under the family code, we still talk about the best interest of the child. Now, as far as the court is concerned, some of the paramount considerations is, one, the child should have a meaningful relationship with both of the parents. In other words, kahit na one of the parents is, for example, is facing, may DVO siya, assuming yung one of the parents even has a DVO against him, or even if one of the parents nakakulong, or even one of the parents criminal, merong drug offender, blah, 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 there is still an expectation that it is still to the benefit of the child for the child to have a meaningful relationship with both of their parents. When you speak of meaningful relationship, it doesn't have to mean 50-50, but there should be efforts, opportunities for both parties to develop that meaningful relationship with both parents. Of course, it's also important for the court, and this is, it's something that's really important, to protect the child from physical or psychological harm, from being subjected to, exposed to, abuse, neglect, or family violence. So what typically happens is that when a party applies for a parenting order, kasi nga wala silang informal agreement, and I'll try to touch on that before I go, before the court will take cognizance or allow an application for parenting order to proceed, the parties must first have gone to a family dispute resolution practitioner and get a Section 36I certificate under the Family Law Act of 1975. But if there is an allegation of domestic violence or family violence, then there is no requirement for a Section 36I family dispute resolution practitioner, and the court will consider an application for a parenting order. The other aspect, and then just quickly, both parents continue to share responsibility for the child. Now, childcare arrangements, there are three ways by which there could be arrangements over the child, assuming na naghiwalay mga mag-asawa. It could be an informal arrangement, pinag-usapan lang, ganito, ganyan, pera, whatever. That's informal. It is not binding. It cannot be enforced by the parties. The police will not even get involved. So in other words, if there is no court order, there is no such thing as kidnapping of a child. So in other words, kung naghiwalay ang mga mag-asawa at one of the parents biglang tinakas yung anak at hindi pinakita sa kabila, the other parent, the Queensland police cannot intervene. They don't have jurisdiction to intervene unless the child is in danger. But assuming that the child is not in danger, the police cannot intervene. The police cannot file kidnapping because there is no kidnapping, mainly because it is assumed that a child should always be with a parent. So the problem with an informal arrangement or with a parenting plan is they are not enforceable and they are not binding. Okay, a parenting plan, medyo mas maliwanag to. Okay, these are arrangements about who says what on what days, blah blah blah, about expenses, etc. Again, not binding. Now, if the parties are able to agree on an informal arrangement or a parenting plan, then they need to apply to the Federal Circuit and Family Court of Australia for parenting orders. The parenting orders can be done both ways. One is by consent, meaning yung mga parties agree by consent, okay, these are the arrangements in relation to children, again with a requirement that both parties must seek independent legal advice. Or if they cannot agree, then they have to go to trial, and that will be when the courts will issue a parenting order. But in general, as far as applications for parenting orders are concerned, maybe about 80% or several are of court, mainly because it's quite expensive for the parties to have to go through an application for a parenting order. It's expensive in relation to lawyers. There's the uncertainty about what the outcomes will be, questions about self-represented litigants, which the judges frown upon, etc. 6:46, I need to go.
Okay.
Okay.
Oh my God. So,
okay.
Thank you very much, Manjo. There's more questions here. A lot of people sent me a personal message. But
thank you for the opportunity, and I need to go. Bye-bye, everyone. See you
Thank
soon.
you very much. Thank you very
Bye-bye.
much. You made everything clearer. All right. Thank you.
Bye-bye.
Maraming salamat. See you next time. Okay, so we're back now. So thank you very much to Manjo for sharing all his thoughts about family law. Napaka-interesting sana nung conversation kanina. Kung meron pa sanang time, marami pa tayong pwedeng itanong. Pero, okay, because we still have 15 minutes and we promised to stay with you until 7 o'clock, I will be entertaining questions about partner visa kasi ano ba ang relasyon ng family law dun sa partner visa na ina-applyan, no? I think most of you are temporary visa holders, kagaya kanina nung tanong ni Andoy Pruni. Again, ang tanong niya, ma'am, so it means if you are in BFGF relationship of Aussie citizen, better to register your relationship, especially you're holding tourist visa or protected in domestic violence in case it happens. Now, first things first, Andoy, if you are in an abusive relationship, there is no point and you shouldn't be staying in that relationship. Do you get that? I don't know. So it's a question of love, I guess, but then it has to be the proper love, the right love for you, the love that you deserve. Um, not not about the visa anymore. It's about your dignity as a human person. It's about you. No, so um, and it's about your protection as well. It's about your psychological health. It's about your mental health. Now, if boyfriend-girlfriend relationship pa lang kayo and then meron ka nang nararamdaman na abuse in whatever form, don't look at the benefit of the visa for you because it's not going to be a happy one. Okay, so maybe shift the mental what's the mental operations, no, na you're here, you're on a tourist visa. If you love your partner, then there must be at least equal rights between the two of you, regardless of whatever visa you're holding. It shouldn't be the question of what visa you're holding. So that's my that's my advice, Andoy, Pruni. And if you want to get married and happy kayo nung ganoon, yeah, it's okay, but you have to make sure that you are that you have the rights and you are not in an abusive relationship. Okay. And registration of relationship is not the answer if there is an abuse in the relationship. It's again, if you are moving towards a visa application at some stage, remember the 4 aspects of relationship that I said. No, so it's financial, social, commitment to each other, and domestic or household aspect of the relationship. All those four aspects must play together. Hindi separated na, yeah, okay, I've got the registration of our relationship certificate, we are okay to go. No, so don't view it that way. It has more meaning. It has more in a relationship than just a piece of paper. Okay, so parang naiba yung ano natin. No? But anyway, so I have some questions. No? I think I received some questions, direct messages to me by some of you. But before I answer those questions, remember na yung partner visa natin, kung kayo ay holder na ng temporary partner visa, say for example 820 o kaya naman yung 309, and something happens in the relationship. Now let's say for example merong domestic violence, don't be afraid because you can still get your visa. No? So we have a lot of cases, we've done a lot of cases that the partner or one the Filipino or Filipina are in abusive relationship. They are in 820. They tried to stay in the relationship because of the visa, but when she found us and where he found us, then we explained to them that they shouldn't be staying in an abusive or in a domestic violence scenario, because that's one of the exemption wherein you can get your permanent visa. Now, another exemption is when there's a child between the relationship. So if say, for example, the relationship broke down, you can still get your permanent visa if there's a child in the relationship. The third one, of course, if your partner or your sponsor passed away, then and you are a holder of 820, you're thinking, okay, I'm not going to get my PR, which is the permanent visa stage. You can if that happens. So those 3 scenarios, you can still get your PR if you are in any of those 3 scenarios, okay? And that is what I'm saying. No, don't stay in an abusive relationship in the fear that you will not be able to get your visa. If you are in an 820 visa or 309 visa, you're holding that, then yes, you can, provided that there is a good evidence that you were in fact the victim of domestic violence. Now, for BF-GF relationship, this is the point wherein you have to actually identify what kind of relationship do we have. Now, if it is a de facto relationship, you have to meet the 4 aspects of the relationship. Always remember, financial, domestic or household aspect of the relationship, social, and then your commitment to each other. Kung wala yun, kung hindi present yung mga yun, then probably you're not in a de facto relationship and you're probably not eligible for the protection of even applying for a partner visa. Okay, so now let's go to some questions sent to me. Oo nga, dumami yung question. Oh my God. Okay, so my Australian partner has debts such as SPER, ano yung SPER? SPER, and bond loan, but she's actually paying it via fortnight, auto debit for bond loan, and weekly for SPER. Can she still sponsor me for a partner visa? She's the main applicant, Australian citizen. What about vice versa? I will be the main applicant, the Pinoy. Can that still be affected? Okay, issue is sponsorship. Kung may utang yung sponsor at binabayaran yan, pwede bang maka-sponsor para sa partner, para sa kanyang partner? Yes, you can. Hindi na po kasama yung financial ability ng sponsor sa pinag-uusapan nating partner visa. Yes, you can. So sponsor must be an Australian citizen, eligible New Zealand citizen or a PR over 18 years old, and walang domestic violence order. In some cases, merong iba na merong domestic violence order. Depende sa circumstances. No? Maaring mabigyan ng submission yon sa immigration. It's not easy, but it's worth a try, especially kung may kung matagal na yung domestic violence at marami ng mga pagbabagong naganap. Okay, the second question is my Australian partner, GF. Okay. This is what I'm saying. That's why I'm confused with your question. Sasabihin yung Australian partner nyo tapos GF or BF, no? Okay. Australian partner, ano to, de facto ba o talagang GF, BF lang? Okay, but anyway, my Australian partner, GF, and her husband had been separated for 3 years. However, they are undergoing battle for case for their 4-year-old son. Now, for instance, we want to lodge a partnership visa or de facto. Will her situation hinders for doing it or will it affect the approval of the partner visa? Now, if you are together, kahit na may asawa, halimbawa, yung Australian sponsor nyo o ikaw, kahit na may asawa ka but you've lived together 12 months and you satisfy the 4 aspects of the relationship, yes, you can. Okay? Hindi pwedeng magpakasal kasi nga wala pa kayong impediment doon sa inyong dating asawa or kung kasal. Pero kung asawa nyo de facto at hindi na sila magkasama, kayo na magkasama, you have to meet either 12 months. 12 months lang. Hindi nyo pwedeng, ano ba to, married ba kayo? So I have to clarify kung married sila kasi kung married pa siya dun sa dati niyang partner, obviously, hindi niyo pwedeng iparegister yung relationship niyo. Kasi pagka pinaregister niyo yung relationship niyo, one requirement is dapat hindi married yung nagpaparegister, yung both parties. So ang pwede niyo maging recourse is living together for 12 months and meet those 4 aspects of relationship. Okay, number 3, how will I know or check my Australian partner for her record without indirectly asking her to file for a federal or national police check? Because she had mentioned to me that during her teenage years, around her 20s, she was living in her uncle whose house was a drug den, marijuana, and it was raided. Could it possibly she had a criminal case before? If she had, will it affect the partner visa application? If her record had been cleared already, is it still affected? Okay, one question, how do you know kung may record yung partner mo? First point is you have to ask your partner. If you're truly in a partnership relationship, then your partner would be able to understand why you are asking the question. Ngayon, kung hindi niya sasabihin at meron ka pang doubts, I guess, tanungin mo yung mga kamag-anak kung ano na yung nangyari doon, or make it clear, no? Because you can't really ask for a federal police check of the other person unless you are authorized to do so. Now, with partner visa application now, if there is any record, meron na pong sistema ang immigration with the sponsor giving a blanket consent for the immigration to divulge or to say to the applicant if there is a substantial criminal record yung inyong Australian sponsor. So malalaman nyo pa rin yun. No? Ngayon, will it affect the sponsorship or the partner visa application? It depends. No? Merong iba na by law, so dapat ang conviction is no more than 12 months. Dapat ang conviction is less than 12 months. Pag sumampa ng 12 months in conviction, 12 months imprisonment or jail time, then that will of course affect the partner visa application. Pero in many instances, we were able to fight for the case of our clients. Kasi nga may iba't ibang circumstances na yan. Like if 20 years ago, wala namang problema or things like that, or nagbago na, yeah, we can fight that to the immigration. So depende sa mga circumstances. No? Pero kung hindi naman domestic violence yon, kasi domestic violence, immigration is very, very particular about that. So yun, medyo may laban siguro or pwede pang i-prove na pwede siyang mag-sponsor. And then number 4, my partner filed for a divorce. Will the custody battle between their children may delay the approval or grant of the divorce, or cannot grant the divorce? They have incoming hearings for the case. They filed for custody, but no DV order. Also, the divorce she applied, there is an incoming hearing. What will be the hearing purpose just in case? Yeah, that is what Manjo was trying to explain. It's a different process in Australia. If you're in the Philippines, the court hearing or the issues, the family issues will be heard all at the same time. Parang isang basket na malaki, nandyan lahat ng issue and then i-deal sa court. But in Australia, it's different. So divorce is a separate proceeding. So normally, nauuna yung divorce. No? Kung na-meet yung 12 months that you're no longer living together, the divorce can be granted. Ngayon, yung issue naman ng custody, in fact, sabi nga ni Manjo, this is no longer a question of custody. Hindi na ginagamit yan sa Australia. Baka sa Pilipinas ginagamit pa. Ang pinag-uusapan dito is parental responsibility. So yun yung i-hear ng court. But that is a separate proceedings. Hindi nyo kailangan mag-away na mag-asawa. In fact, that's the basic principle in family law now. No? So hindi nyo kailangan mag-away na mag-asawa dahil lang sa bata. What is the best interest of the child? Kailangan kayong dalawa ng anak nyo. So wag nyong gawing pag-aaway yun. I think yun yung pinaka-importante. No? Tingnan nyo ano yung parehong maiaambag para dun sa kapakanan ng bata. Tanggalin na yung ego o yung mga pride at yung mga away-away. At the end of the day, you're very separated. You have no business about each other. Your business is to look after your children na hindi na nasasamahan ng mga emosyon kasi kawawa yung mga bata. Yeah, so kung merong mga ganun, hiwa-hiwalay na proceedings yon. But it won't affect. Kung divorce ang pinag-uusapan, it doesn't, hindi dependent yon dun sa kung anong mangyayari sa custody. Hindi rin yan dependent kung anong mangyayari dun sa property. So they are all in separate proceedings. Okay, so I think that's about it. I think I've answered all the questions. Tigil na muna yung padala. Next week na lang ulit tayo magsagutan ng inyong mga tanong. Okay, so maraming salamat po sa inyong mga questions and maraming salamat for participating in this kind of discussion. Next week, it will be interesting. So that will be our last special edition because what we're going to do next week is to talk about properties and to talk about succession law. So kung kayo ba ay may mga properties na ano nang gagawin nyo? Sino maging tagapagmana nyo? Kailangan nyo na bang gumawa ng will at this point in time? Or is it the right point for you to ask your parents to do a will and whatever is your participation there? And also for those people who are thinking of creating or building a business, that will be discussed next week as well. And those people who are thinking of buying properties in Australia, real estate or whatever assets that you want to build or to start building. Now, it's time for you to come back on Wednesday because that's the area that we are going to discuss. Okay, so thank you very much, everyone, and we'll see you on Wednesday. Bye-bye.